I'm not sure if they're, oh, they're coming in.
Judges out.
So
There they come.
Okay,
Um,
that's fine.
this case is an indecency with child by contact. So they did a jury. The state presented their case. And so the way it works, a jury is selected. Once the jury is selected, in my court, I always have alternates. So normally in normal felonies, and there are some felonies that are hybrids, but true felonies, there are 12 jurors on a panel. I always do 2 alternates because you never know if something's going to end up happening. So if let's say a juror were to be involved in an accident, and we've had jurors been involved in accidents before, if you go under 12, in order to continue with the jury trial, both the state and the defense will have to agree that they'll continue with less than 12 jurors. So that's why I always do alternates. So the state put on their case, the defense put on their case, and both sides have rested and closed. Once both sides have closed, then what ends up happening is a jury charge is made. It's titled charge of the court, but it's just a jury charge, and it's an instruction to the jurors. Are they lined up? I'll explain the rest to you.
Sure.
Yes.
Is there any way I could possibly ask for 20 minutes instead of 15?
Are you going to take the entire 20 minutes?
I'm not sure. I'd rather
Okay.
have too much time than not enough.
Okay, I will give you 20
Thanks.
minutes.
Thank you, Judge.
And state, I will give you 20 minutes.
Thank you. And if I could get a 5-minute warning.
All right.
Thank you, Judge.
All right, Deputy let me call the case. Court is calling 2022 CR 1331, State of Texas versus Alejandro Raymond. Can I have parties announced for the record for the state? I'm sorry, Raymond Alejandro for the state,
Travis Banks from the state of Texas.
for the defense.
Matthew Allen.
All right. And are you Mr. Alejandro?
Yes, ma'am.
All right, are both parties prepared to proceed? State,
Yes, Your Honor.
defense?
Yes, Your Honor.
All right, any objection from either side to the intern sitting here?
No, Your Honor.
No objection.
All right, we are ready to proceed.
All right, the jury.
All right, everyone, please be seated. Good morning, everyone. All right, so I want to let you know that the person who's sitting to my left is an intern. So he has absolutely nothing to do with this case. He's a student who's thinking of entering law school. Okay. All right, what I'm going to do is I'm going to read to you what's called the charge of the court. It's the jury charge. You do not have to memorize it. A copy will be given to you when it's time for you to deliberate. Right. Charge of the court. Members of the jury, the defendant, Raymond Alejandro, stands charged by indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 21st day of February 2021 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of indecency with a child by sexual contact if with a child younger than 17 years of age, and whether the child is of the same or opposite sex, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 2, child means a person younger than 17 years of age. Sexual contact means any touching by a person, including touching through clothing of any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person. 3, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. There is no limitation period for the offense of indecency with a child by sexual contact. Therefore, it is sufficient if the state proves that the offense alleged was committed sometime before February 8th, 2022, which is the date the indictment was filed. 5, now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of February 2021 in Bexar County, Texas, the defendant, Raymond Alejandro, did intentionally or knowingly engage in sexual contact with Jesus Leza, a male child younger than 17 years, by touching part of the genitals of Jesus Leza with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service or any text or instancing messaging service, or any social media platform, internet, chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. If at any time the court instructed you to disregard testimony, you are reminded to so disregard it, and you are not to consider such testimony for any purpose whatsoever. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror was certified thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty of the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
You may proceed.
The state will reserve the remaining time for rebuttal.
Defense, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
Hmm. 873 days. That's how long it took for Raymond to be able to tell somebody who actually wanted to listen and hear him tell you what actually happened or didn't happen on that day. You and each of you do solemnly swear that in the case of the state of Texas against the defendant, you will true verdict render according to the law and the evidence, so help you God. So again, that's why we went through that process, because there was people that had some bias or things that they didn't think that they could sit on this case. But each of you swore that you were going to take just the testimony and evidence that was presented and nothing else to decide this case. Now, I apologize if my voice seems shaky or I seem a little bit nervous. For a defense attorney, this is the most nerve-wracking part, because I go home at night and I wonder what I could have done. Could I have done more? Should I have done something else? Did I come off too abruptly? Because this is the last time I get to talk to you. And again, we talked about the burden of proof, and we talked about why that burden of proof is beyond a reasonable doubt. Because in a case like this, like the judge said, there are circumstances, and in this case where a child's under 13, there is no probation. It's prison, and you're talking about someone's life and liberty and freedom, and that's why it's the highest burden that we have. We talked about, should the burden of proof be lower because it involves a child? And each of you again swore, no, that's not how it works. And you're gonna abide by that. Talked about the burdens of proof. What it takes for an arrest, probable cause, way at the other end. We talked about clear and convincing evidence. And I asked a few jurors, how much evidence would you want in a case where the state is trying to take your children away? I said, you better bring all of it and more. I said, okay, well, now you go a step further. And that's, again, I can't give you a definition, but it's even further than that. Again, the burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. And we talked about three possibilities when you're back there. Might be thinking, not guilty, guilty. You might be thinking, man, one person is saying this happened. Another person is saying it didn't happen. I don't know. And it's not 50.001%, right? It's beyond a reasonable doubt that you have no reasonable doubt that it didn't happen. And again, you might be thinking, I don't know. And we talked about, what does your verdict have to be? It has to be not guilty. Presumption of innocence. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. Again, so that stays with Raymond throughout, that presumption of innocence. And each of you again swore, yes, I can follow that. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. We talked about speculation or guessing, or well, maybe there's something else, or maybe no. It's what came from that witness stand and the evidence that the state proved. Again, there's no assumptions, there's no guesswork, and the only gaps that you have, if you're thinking, well, I wish I knew this, or I wish I had this, that gap is filled by the presumption of innocence. Your job, you're the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given in testimony. Again, Judge Boyd read that jury charge. She gives you the law. You'll have that with you, but you get to determine the credibility of the witnesses. Now, the state kept trying to get the investigator to determine the credibility of the witnesses, but that's your job. Again, I don't get to come up here after I sit down. Probably thankfully for you, I don't get to come back up here and talk again. But the state comes up. So what I think they're going to say is use your common sense, and I agree, use your common sense. But again, fill those gaps with the presumption of innocence. Protect the community. Children need to be protected. Again, this isn't a case of this side thinks that sexual contact with children is wrong and we think it's right. That has nothing to do with it. Again, it's the evidence that was presented in this case. Okay, well, yeah, he had some inconsistencies, but he's young, or it was a long time ago, or those don't go, whether they shared a room or didn't share a room, those don't go to the elements. But we all know that those are important. That I told you it was going to be a general allegation with very few details. And the very few details we got were inconsistent with each other. And we know that that's important to judge credibility. So again, what they told you, he came up here in opening and told you he was going to talk about some incident afterwards in the living room. And then he asked Jesus, and Jesus said, no, that was it. I didn't see him again after that. So again, zero testimony or evidence of that, of what he came up here and told you he was going to prove to you. Again, he told you that he never saw Raymond again after that incident. And the state, again, they'll tell you these cases are important. I agree, they are important. Jesus said, yeah, I've talked to him once in the last 2 years, talked to him last month. You're instructed that you're not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. Okay, so it's not which side you like more. It's not that we feel bad. I'll tell you right now, whatever your verdict is, there are no winners. Okay, you heard from the family themselves that it has split the family. You can literally see it in the courtroom. It has split their family. And your verdict, one way or the other, is not going to repair that. Okay, so that's not a consideration. Again, it's about the facts and evidence that were proven in this case. Investigation. The deputies made a decision they were talking about warrants and cases less than an hour. And they told you themselves that they didn't even get details. They got a general allegation. They already were telling the family, okay, we'll get a warrant. Don't worry about it. They didn't try to collect any physical evidence. And they did nothing to corroborate. And I'll talk about Investigator Salazar, because the testimony that the deputies and investigator gave is frightening for everyone in Bexar County. That's the investigation. That if someone calls the police and says, I was sexually assaulted, that's it. They don't care. They don't care if they talk to Raymond. They don't care about getting DNA evidence, even trying to get that DNA evidence. Again, is it easy or difficult? A phone call to the police with a general allegation, and that was it. That's all they needed. And they told you we don't try to get more information. So again, the deputies, they at the scene, no one's crying or hysterical. They asked some basic questions and they left. They told you, oh, we're not qualified to ask investigative questions. So Salazar, again, the deputy said, well, all that stuff that's on the investigator. Okay, so what did Salazar do? Well, first of all, she told you, well, I had to attempt multiple times to try to contact the mother. I called her, I texted her, had to get her in months later to get a written statement. They couldn't contact Raymond. That is absurd. Okay. He's on the same phone plan for a few months. He lived at his mother's address. Okay. That they couldn't get contact information for him. I'm sorry. Again, that's absurd that they couldn't even attempt to contact him. The things that Investigator Salazar was saying, my victim, and we go out with a mindset not to upset the victim. Again, it's not a mindset of unbiased and let me investigate what's going on here. It's a mindset of, okay, I don't want to upset that person. Talk about within 120 hours. And the deputies were out there within 120 hours. The deputies didn't ask about showering. That's at the same exam later. So again, they're going to say, well, we probably couldn't have gotten any DNA anyway. But could you at least have attempted to try to get the clothes? Maybe if you actually get an address, you can go to Raymond. Maybe you can try to get DNA from him. Would you still file if you talk to in a hypothetical scenario, if you talk to the defendant or the suspect and they deny it, would you still file it? Yeah, absolutely. It didn't matter what he was going to say. It didn't matter what anything happened. They were going to go forward with it regardless. Again, it was biased and there was zero regard for the presumption of innocence. So, Jesus, couldn't remember a lot of details or what he said previously. Again, you get to judge the credibility. There wasn't really reactions to the questions. And to me, that signals not understanding the ramifications that someone's life, that someone is going to go to prison based on what you're saying. And it's a general allegation. So, Jesus, well, I didn't testify. Well, I don't remember what time. Again, Regina said, well, he told me it happened at 5 a.m. My mom told me to go to sleep. Well, he doesn't really have a bedtime on the weekend. And we know that was Saturday night leading into Sunday. And again, you may say, well, they're going to say, well, these don't go to the elements. But these are the few details that we actually have. And so that's why they're important. Went to school the next day. Well, again, the next day was Sunday. You didn't go to school. He was steadfast. I initiated that conversation. I took my mom and I needed to tell her. And she said, no. I took him and I needed to talk to him. Again, testified. Well, I don't know how long it was. And it lasted 15 minutes. Okay, we shared a room. Well, we know that they didn't share a room. Shared a phone. We know that they didn't share a phone. I heard footsteps. That was the first time he ever said that. Just randomly 2 years later, now remember, I heard footsteps. Didn't testify about knocking, but again, we know they told that he did knock. Not remember the CPS. But he told CPS, okay, well, yeah, I'll do your interview if I can miss school. I was pretending to be asleep so I wouldn't get in trouble. But then I saw it was Raymond coming in. So to me, why are you still pretending to be asleep? You were worried that your mom was coming, okay, but then you see it's Raymond. So again, why are you, it's just common sense, why are you still pretending to be asleep if it's just Raymond coming in? Pretending to be asleep, but he's got the TV on with the lights on. Again, no mention of TV before. He says underneath clothes, but then changes it to pull pants down. So Raymond, he didn't have to get up here and testify. He could have got up here and said, oh yeah, the family, they hate me. And they told me they were going to get me. And he could have told you, you know, he could have made up some sort of motive. Oh yeah, Jesus was jealous of me or whatever the case may be. He told you the truth. We had a great relationship. He was being honest with you. And you judge his credibility the same. Everybody starts out at the same level. Again, he subjected himself to cross-examination. And I don't know, they might make a big deal. Oh, well, I asked him, did you touch him in bed? Well, the whole trial we're talking about, it's a touch case, touch DNA. So when they ask him, no, I didn't touch him, because really what you want to know is, did you touch them inappropriately? Okay, so he says no. Of course, if you're laying next to somebody in bed, you're gonna rub up against them or touch them. And so he was wondering what was going on. Why, that's common sense. Why are you asking that? And he says, well, yeah, I don't remember. It wasn't memorable, whatever the touching was, but it wasn't inappropriate. They brought in Samuel Brago. Told you important to follow protocols on those forensic interviews. The forensic interviewer was not here. We don't know what protocols were followed.
5 minutes.
Thank you, Judge. Again, he said it's a neutral party. Police are there and consult on what questions to ask. He didn't do the interview. And what did he tell you? Some children tell the truth and some children lie. Okay. Julie Vereen, concern for sexual abuse. Anytime someone says that they were sexually abused, she's going to say that. Normal finding. Again, didn't tell you anything. Those two witnesses, what did they tell you? It might have happened, it might not have happened. Do we always know why someone would make an accusation? Again, and I asked you, would you require me to prove a motive? Because I can't. It's in someone else's mind. So again, motive. Some things that came out that I'll tell you. It's a new family. There's a 1-year-old. There's a lot of things going on. Both parents are working. Again, maybe seeking attention. I don't know. Again, I'm just trying to give you some things that stood out to me. It said he was a moody teenager, didn't want to go to school. Again, I don't really think he understood the ramifications of what was going on. And we talked about, is that ball, once that ball gets rolling, well, he told his mom, and immediately the family is called. So the family's involved. So that's immediate. Then the police are there. And then you're talking to other people. Now the family is already split. That's a lot for anyone, let alone a 13-year-old to walk back. Again, common sense. They told you Raymond had, he would watch the kids, he'd be alone with the kids. Okay, so common sense. You have the opportunity, you have that time alone, but what does he supposedly do? He waits until Sunday at 5 a.m. with a door that we know can't lock, when the entire family is in the house, when someone could easily yell or scream and wake up anyone, when a 1-year-old, if you had a 1-year-old, can wake up at any time to wake up people, when they can see whether they can look out and see whether he's sleeping on the couch or not. And when a police officer with a gun is right down the hallway, that's what they're telling you. That doesn't make sense. And that he knocks on the door to announce that he's coming. Again, those things just, they don't make sense. Again, the burden of proof, did they prove this case beyond a reasonable doubt? Is it so much that you've been taken to that spot, that you've gone past 50.01%, that you've gone past the moment that was enough evidence to take someone's children away, that you've gone all the way to that edge of the wall, that you're convinced beyond a reasonable doubt? Did they do that? And that's your question. That's your only question. Did they take you to that spot and give you enough credible and reliable evidence that you say beyond a reasonable doubt, Raymond did that and he's guilty? And they didn't do that in this case. Again, there's no winners here. What is done is done. But your single job.
1 minute.
Thank you, Judge. Did they produce that evidence, reliable and credible evidence that you're the judge of the credibility, not the state, not their investigator who didn't do anything, you, because you were in the courtroom listening. Did that take you to the spot that you say beyond a reasonable doubt? And ladies and gentlemen, they did not. And again, it's frightening that the allegation and investigative work in this case, or lack of, but again, did they take you to that point? And they didn't. And because of that, I ask you to find Raymond not guilty. Thank you.
All right, State, are you prepared?
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. May it please the court, opposing counsel, and ladies and gentlemen of the jury. He never asked Jose and Regina why he was no longer welcome in their home. He told us. He never inquired with Jose and Regina as to why he was getting kicked out of their home, because he knew exactly why, and he knew that he deserved it. Even though they were still paying for his phone, he told us he made very minimal effort to even reach out to them and inquire why he was no longer welcome in their home. He said he called, but they never called back. I guess he just dropped it. I guess it wasn't that big of a deal, but he didn't send a text asking why. He didn't send an email asking why. He didn't plead his case to them. He made no effort really to reach out other than a phone call, even though these people trusted him with their children. They trusted him in their home. They even trusted him to sleep in the same bed as the children. And Raymond, by his own words, said he had a great relationship with them. He said they were some of the best family he'd ever had. Those were his words. And it makes sense. Everyone here, every witness on the witness stand corroborated that fact. They all told you that he would help out around the house, that they were like brothers, until one night when Raymond walked down the hall and went in to Jay's room. Raymond pulled down Jay's pants and he touched Jay's penis with his hand. And we heard that he did that for 10 to 15 minutes. And we also heard that he was trying to masturbate Jay. We heard that Jay was kind of reluctant to use that word. Jay's a young man. And I can understand why that's a little bit embarrassing, but we heard from his mother, who was able to tell us what he said back when it happened. And that's what he told his mother that Raymond did to him. And the rest of the family clearly had nothing against Jay until they heard about the night, or nothing against Raymond until they heard the night when Raymond sexually abused Jay. So Regina and Raymond both told us that there was kind of a deal in place. That Raymond would help the family with the newborn. He'd help around the house, he'd watch the kids, and he'd get to stay on the couch. Nobody disagreed about that. Raymond told us that. And all of a sudden, that agreement has changed. Raymond told us that they came home. Everything was weird. Nobody would talk to him. Everybody went into their room, shut the door. Nobody would say anything. And then all he got was a phone call from Angel that Raymond needed to go. Raymond needed to pack his things and leave. Now, Raymond didn't go to the door, like say, hey, like I understand it's closed, but he could yell through, hey, I thought we had a deal. What's going on, guys? He didn't really do anything. Does that make sense? We're talking about using common sense. Does that make sense that someone with that type of a relationship with the family, he was basically another family member, he's getting pushed out? Why wouldn't he say anything? Why wouldn't he protest? Why wouldn't he at least call through the door to find out what's going on? Because he knew exactly why he was getting kicked out and knew that he deserved it. Let me talk about some technical matters with the case that we need to discuss. On or about some date anterior to the indictment. I don't want you to be confused by that. The date in the indictment is the date that we talked about on the witness stand, and it is anterior to the date of the indictment. So you'll be fine with that. This defendant, he was ID'd in this courtroom intentionally or knowingly. That's what he did. He walked right in there and intentionally and knowingly touched Jay's penis when he masturbated it. And Jay was 13 years old at the time, and with the intent to arouse or gratify the sexual desire of anyone. I don't want you guys to get hung up on that either. There is no reason why. There's no other reason. There's no innocent reason why someone would go into another person's room, pull down their pants, and masturbate them for 10 to 15 minutes, other than to arouse somebody's sexual desire or gratify that desire. So I want to touch on a couple of the defense arguments. First off, They said Jay's just a moody teenager who's jealous of his siblings, so he made up this lie. That is absurd, and that is insulting to probably everybody in this room. That just explains all of this. There are lots of moody teenagers. That's not what they do. Then he said 873 days. He stood up 873 days. He's waited. Well, guess who else has waited 873 days? Jay. And Jay has had to deal with this for 873 days. You heard about the SANE exams, the forensic interviews, the officers who come to his house, and then he has to come meet with the state to prepare for trial. This is an ordeal, folks. This is not something that somebody would want to voluntarily put themselves through. And then he gets on the stand and he has to say these things that he doesn't want to say to this room full of adults. It's absurd that a child would want this right now. That a child would want that. And then he says it's hard to say that this isn't true. It's very easy, folks. It's very easy. Maybe he'll be grounded for a few weeks because his parents will be mad at him. But he could have easily recanted at any point. He hasn't. And if he did, you would have heard about it from defense. Then he talked about sharing a room. Oh, well, he didn't remember whether they shared a room. Well, remember the testimony. They shared a bed. So yeah, would he not remember, was that the time when we were sharing the bed or not? They shared a bed. He misrecalled it. I don't think y'all should hold that against him, that one lapse in memory. They also said the decision to get a warrant was made in less than an hour. Well, when you make a report to the police and you report the full crime to them, yeah, they jump into action. They go ahead and they get a warrant against the person you said did the crime. That's the start of the investigation. That's not saying he's guilty. That's not ignoring any type of presumption of innocence. That's how they start the investigation. That's not anything out of the ordinary. He said that the DNA evidence was not attempted to be collected. You heard from every witness, the same nurse, the detective. This isn't, in a case like this where it's just a touching, you generally don't find evidence, especially when there's that lapse of time. This is all normal. His complaints about the investigation that he's putting in front of you are just normal things in an investigation that you will see. That does not make somebody not guilty of the crime. And one thing I wanted to point out, he said, well, the officer said she would still file charges even if he said he didn't do it. Is that surprising to anybody here, that when a police officer interviews somebody and they say, well, I didn't do it? Well, if the police officer just said, okay, well, I'm fine, you said you didn't do it, I'm not going to file charges then. If that happened, then everybody would just say they didn't do every crime and nobody would ever get in trouble for any crime. That is absurd. That the fact that it's not ignoring someone's presumption of innocence to go ahead and file charges. Again, it's just the filing of charges. You're not found guilty when charges are filed. So let's return to the discussion of the facts. Immediately after the abuse happened, Jay was somewhat reluctant to tell his mom about it. He didn't tell her that same day. You remember, it was that Monday, everybody came home. Jay said, everybody thought the son was acting weird, and even mom and son agree. They don't exactly agree on who initiated the conversation, but Jay said, Mom, sit down. I've got something to tell you. And mom said, that's not normal for Jay. Jay doesn't break news to me in that way. And mom's got no reason to lie about that. Mom has basically no dog in this fight. You've even heard from Raymond. Mom and Raymond had a great relationship. They were great family members. Why would mom have any motivation if these things were not true, if these things did not happen? So he tells his mom to sit down. He breaks the news to her, even though it was difficult. And he knew it was a serious thing that happened. And you could hear Jay saying on the stand, I knew it would be hard on the family. That's also part of the reason he was hesitant. And at some point, the jury will need to also sit down and talk about this case. You're going to go into the back room and you're going to have some evidence. You're going to have the SANE exam. And you remember the SANE nurse talking about the exam that she gave. You'll be able to read the narrative. And you'll find that that narrative is largely similar to the narrative that you heard from Jay. And you'll be the sole judge of witness credibility. And I want to point out that while the defendant, doesn't have to testify, you can't hold it against him if he doesn't. He also doesn't get extra credit if he does. He doesn't get bonus points for testifying, especially if you don't find what he said credible. And I think a lot of what he said wasn't very credible, wasn't very reasonable. It didn't pass the common sense test. And so I think we all know what happened. We heard from Jay, and he told you about the important sensory details. He told you about how he felt Raymond's hands were cold when he touched him. He told you about how he remembered the footsteps coming down the hallway. He told you he remembered the lighting situation in his room. He remembered that the lights in his room were off. He remembered the lights out in the hallway. He remembered it was really late at night and his mom wanted him to go to bed. And let me touch on that for a moment. The idea that, well, because he doesn't have a bedtime, well, it's not possible that mom told him to go to bed on a particular night. We're talking 5 a.m. I think a lot of parents will at some point say, hey, it's 3, it's 4, it's 5, go to bed, son. So the idea that he doesn't have a bedtime doesn't mean that his mom couldn't have told him to go to bed. So I think there's a lot of defense distractions you were presented with, but when you look down at the elements and you remember what Jay told you about that night, it's pretty clear what happened, and the elements have been met. Jay told you about Ray coming into his room, pulling down his pants, touching his penis, and masturbating him for 10 to 15 minutes. He told you his story, and now you're a part of it. And now it's time for you to do the only proper thing, and that is to go into the jury room and find him guilty. Thank you for your service.
All right, ladies and gentlemen, I kept telling you I would let you know when it was your turn or time to deliberate. So Deputy Laura is going to take charge of you. I'm going to ask that Monica Vara and Adam Gonzalez, if you will remain behind, please. All right, everyone, please rise. All right, everyone, please be seated. State defense. Let me see that. Oh, thank you. So in this case, it's an, I'm sorry, could you close that door? Thank you. Oh, do you all want to talk with Diana about what exhibits are? I know there were not that many exhibits, but just to make sure.
Sure. Here's just the photo.
Yes,
The photos.
yes, I only have 2 on my notes. Yes. So in this case, as I was saying, 12 jurors are selected. And I always do alternates because when you go below 12 jurors, the only way you can continue with deliberation is if both the state and the defense agrees to continue. If either party says, hey, we're not going to agree to continue, then what? Oh, you have signatures for me? Oh, thank you. Oh, and there's fruit in the back if you want some. Oh, nothing. You know, we always have food here. Yes, yes, so I'm trying to be healthy, so we have fruit in the back. All right, thanks.
Just ourselves.
So if either side decides, yeah, I'm not going to continue with less than 12 jurors, you can't force them to go. So that's why I always have alternates. But the thing about having alternates is they are not allowed to participate in the deliberations. Yes. So let's say, for example, we have our 12 jurors now, but let's say one of them gets sick or there's a family emergency and they need to leave. Then we can put an alternate in. And once you put an alternate in, they have to start deliberating from ground zero. They can't say, oh, you're the new juror here. Let me catch you up on what we've done. No, they have to start. Yes, they have to restart because those jurors are not a part of deliberations at all. So that's the way that happens. But this case is an indecency with a child by contact. So the state put on their case and then the defense, they can put on a case or not put on a case if they so choose. But they decided to call their client. If they did not call their client, the jury was not to consider that, and they're not allowed to consider that at all. Oh, just 1 second. Hey, are you waiting for me? Yes. No, no problem.
I want to see what other
Mhm. Oh, are they on the docket today? Are they indicted? Yeah, because we don't do pre-indictment cases here. Okay, all right. If he's indicted, if you can grab the file and I'll get an attorney down for you. You're welcome. So
Yeah.
the state calls their witnesses and then the defense can call witnesses or not. And people say, oh, the defense didn't put on a case. Sometimes their case is cross-examination because cross-examination and the answers are evidence. Right? So this is a case because of the age of the complainant. His client is not eligible for probation. So if he, yes, so his range of punishment is 2 to 20 years in prison if he were to be found guilty. And then if he's found guilty, then the jury would deliberate on punishment because the defense decided if he were to be found guilty, they would go to the jury for punishment. And punishment, what ends up happening is that's the time where the state can put on, you know, whatever evidence they want to. If somebody has a criminal history, they can put that on, depending on what it is, because there are certain guidelines and rules to that. It's the time where the complainant can testify and say how this has impacted him. And a lot of people think that victim impact statements come in during guilt innocence. It doesn't, because you're not to let bias or sympathy play any reason, you know, play any role in whether you find somebody guilty or not. So punishment, that's where people present their mitigation. The defense will present a mitigation. For example, sometimes the mitigation is, yes, I know voluntary intoxication is not a defense, but my client was drunk. My client would have never done this if he wasn't drunk. And this is just in general cases. This is not about this case. Or sometimes people will say, yes, my client was not insane at the time of the offense, but my client has mental disease. So those are all mitigation. And usually the state will present their case in the form of, all right, this person hit you with a vehicle. How has that changed your life? And they'll say, well, you know, I can no longer walk, or I can't do the things that I would normally do. That's when that testimony
Surrounded
comes
all
in.
these people,
So,
like, you're
When
the-
somebody is testifying in the guilt,
the unknown thing.
not guilty phase,
Do you wanna
that
do this?
person normally would not be allowed to say, oh, this person hit me with the car. I can no longer walk. I'm in a wheelchair. Of course, if you're in a wheelchair, people will see it. But that testimony is normally not allowed. Now, sometimes the defense won't object if they're bringing that up, but it is objectionable. Mhm. No, the defense should or could object to that because it's not allowed. Punishment phase, they can. Yes, in the punishment phase, basically, with some exceptions, everything comes in.
That's what I was. I love that.